Hello and welcome to the My Best Divorce Basics series. My name is Christopher Bruce. I am a divorce lawyer in South Florida, and today's lesson is resolution-focused litigation. The objective of what we're going to be going over is learning the basics of designing a legal strategy that encourages a reasonable divorce settlement at the earliest possible opportunity. In other words, what are the elements of what is typically involved with what your lawyer can do to encourage your spouse to settle early on as opposed to allowing your divorce case to linger? We're going to go over why having resolution-focused litigation is necessary. I will explain what resolution-focused litigation is. I'm going to go over the costs of delay in divorce, why it's problematic for a divorce case to remain unresolved and still outstanding, if it wasn't obvious already. And then at the end of this lesson, we're going to go over how to utilize what I call a net present value settlement analysis for determining when you should accept or reject a settlement offer. In this lesson especially, you need to make sure you consult with a qualified divorce lawyer before you do anything. None of the lessons in this course are enough for you. You need to talk with a divorce lawyer before you take action, but especially on this subject, which is litigation strategy. You need to go over this with a lawyer. So, why is resolution-focused litigation necessary? Here's the deal. It's nearly never the case that both spouses involved in a divorce truly want a divorce and also at the same time have the same goals in the divorce. If you and your spouse were that far aligned with each other, more likely than not, you'd be able to stay married and you wouldn't be in the situation of having a fundamental disagreement or disagreements that result in you needing to get divorced in the first place. It's kind of common sense. The fact is, usually there needs to be at least some form of subtle encouragement in the background as the details of a divorce settlement are being negotiated to help facilitate things moving along a little bit quicker. In other words, it's kind of like a carrot and a stick. There needs to be some form of a motivation for your spouse to come to the table, agree on what they should agree on anyway as a settlement to the divorce so that everybody can move on. Resolution-focused litigation is a litigation strategy, and sometimes doing some of the things needed to keep a case moving, a divorce case moving, can cause some short-term discomfort between everyone. But you know what? The strategies that are appropriate, well, maybe uncomfortable at times, not always in the short term, are going to far outweigh the damages that can come to you, your family, and your bank account, and your relationships if your divorce case gets off track, takes forever, and a lot of money to resolve. That's why there needs to be a strategy set up for getting this all over with as soon as possible. Really, I equate it with some of my clients, the divorce process, kind of like going to a dentist to have a nasty cavity ripped out. When you get there, it hurts like hell. You just want to sit down and get the dentist to drill out that cavity. You don't want it to take forever. You don't want to keep coming back because insurance doesn't cover the cost of everything, even though they say it does sometimes. You just want to get in, get out, and move on. And that's the same thing with divorce. So how do you do that? Well, the way to do it is to have a divorce strategy, a litigation strategy in place that encourages naturally everybody to want to get everything done. So, what are the components to that? I mean, I have 5 points listed here on this sheet, and obviously, you can't sum up the most important thing an attorney can do on one PowerPoint slide or one presentation. This is really the area to where your attorney is the most valuable. The best divorce lawyers are the divorce lawyers who know how to set strategies to get things done on fair terms as soon as possible. But as far as the basic components, have them listed on the slide we're going to go over now. And really, step one of everything is, once you file for divorce, if you want to get your case over with and have your spouse encouraged to settle, you need to get things moving. And what I mean by that is, if there are key witnesses in the case, they need to be set for deposition out in the future. Your spouse's deposition needs to be set. If everybody who has any intelligence knows you're going to have to hire a forensic accountant to get your case resolved, you need to hire that accountant now. If the other side has employability issues, you need to hire what's called a vocational evaluator. If real estate needs to get appraised, you need to get it appraised. You need to start getting the things done that are going to need to be done, and you need to make it known that that's what you're doing. And as it relates to these depositions that I'm mentioning, these are things that don't have to happen now. They don't have to even happen ever in your case, but they need to be set on a calendar, and your spouse needs to be made aware that if the case continues to move on past what should be its natural expiration point, the point to where everybody should settle, your spouse needs to understand that there's going to be consequences. You're not going to stop. You're prepared to prove in court what the settlement offer should be, what you should get under the law, and that you're not going to mess around. So how does this work practically? Usually it means after you file for divorce, soon on in the process, none of this stuff happens immediately or the day after you tell your spouse you're getting divorced, but soon after you file for divorce, your lawyer will work with your spouse's lawyer to set a mediation date. And after that mediation date on the calendar, you want to start having the other things that need to happen in your case if you need to prepare it for trial. And they should usually be close in time to the mediation, which sets up the scenario of, if you go to your mediation, or when you go to your mediation, your spouse knows that if they don't come to the table and agree to a reasonable settlement offer, then there's going to be consequences of moving forward with the litigation. They're going to have their deposition taken next Monday if they don't settle at the Thursday mediation. Things like that. And what that does is allow you to create incentive in your spouse to settle the case. At the end of the day, this doesn't really create a lot of extra expense. It's really, in most cases, nothing more than your spouse's lawyer's secretary setting certain events to happen in your case after the point in time to where your case should settle. And that's really it. I mean, in the short term, there might be some commotion about your lawyers trying to do all these things. They're going to blow the case out of the water, drive up excessive fees, blah, blah, blah. But that's nothing but nonsense, really. It's what has to be done if your case doesn't settle and your goal is going to be settling first. So, element number one of a resolution-focused litigation strategy is to file for divorce and get things moving. The second thing you need to be doing at the same time, and you need to be working quickly on this, is to exchange financial information with your spouse through the lawyers and propose a reasonable settlement offer at the first available opportunity. That means basically, as soon as you can, get together everything that you would need to evaluate to settle your divorce case, send it to your spouse's lawyer, and get any information you need to fill in gaps from your spouse's lawyer. And you want to do that as soon as you can. The reason I advocate for getting all of your information together as much as you can before you file for divorce is so that you can take this step as soon as possible once the case gets moving. Now, once you've exchanged the information that everybody would need to evaluate to determine what makes for a reasonable settlement offer, and you've made a reasonable settlement offer, you need to logically evaluate any counteroffers from your spouse or offers from your spouse as soon as you can. And when you do that in a logical fashion, which I'm going to go over in just a minute, you get your case over with when you should. Another element of the resolution-focused litigation is to set a trial date in most cases as soon as possible, as soon as your legal team is confident that they are ready to present your case or will be ready to present your case in the time expected to get a trial date. And the reason you want to do this is twofold. Number one, in the negotiations, it sends a message to your spouse that you don't believe you're messing around, that you're confident in your position, that you want to get things done with, and you're prepared to go to court to prove your position as opposed to messing around with any offers from your spouse that are ridiculous or just not adequate. And the second reason you want to get a trial date as soon as possible, at least with most judges in family court, is because it can take a very long time to get to a trial. And here's what I mean. With some of the judges down here in South Florida, it can take 9 months from the time you ask for a trial date to get to your divorce trial. And the divorce trial itself, there's no judge and jury in many places with family court. It's just a hearing with a judge that's from several hours to several days. That's it. So, this marriage you want to have over, this divorce case you want to have over, depending on the judge that's assigned to your case, it can be a long time before you even get your day in court. And that means that you're going to be stuck married to this person dealing with divorce limbo until that time. And as an extra special fact, with some of these judges, they work hard, they do a good job, but it can take several months between a trial and them giving their ruling. I've had a judge take, almost exactly a year to rule on a case, and plenty of times when it's been over several months after a trial to when the result is received. So that means as you're sitting here now in your divorce case, wanting to have things over with, if you make the proper request for an end date of trial, it could be over a year before things are done. And granted, with some judges, especially in a little bit more rural areas where the courts aren't as busy, you can be over in much quicker time. Some judges have rocket dockets. They handle their calendar very efficiently, or attorneys don't like doing trials in front of them, and you can get your case over with in a fraction of that time. It all depends on the judge, which is why you need to have an attorney that knows what they're doing and knows the intricacies of the local practice. But most of the time you're waiting a while to get things over with. So if faced with the decision of negotiating for 3 more months with your spouse and then needing to wait over a year to get into trial and get a result, or asking for a trial date now and then negotiating for several months with your spouse and knowing that if they don't agree to something that's acceptable, you have an end date closer in mind from court, I'd go with the later option. It's going to make you feel better too. And then the final element of resolution-focused litigation, it's part and parcel to the first thing I went over, but that's if settlement fails, prepare your case for trial. You get your case over with by preparing it for trial. It's kind of counterintuitive, but if you want things to end, you have to prepare to get them over with in a court of law and show that you're serious and ready to rock and roll, so to speak. And that will show your spouse you're not messing around. And if they have an attorney that's dragging their feet, the attorney is going to feel like they're going to be outworked, or they're behind the 8 ball, and there'll be some pressure in the background on them to make things happen as well. So this is resolution-focused litigation in a nutshell. It's not everything that you need to know, but that's what your attorney is there to do. So there's costs of delay. This is why you need resolution-focused litigation. There are expenses to you if your divorce case goes longer than it should. And the financial costs of any resolution-focused litigation strategy are usually going to be dwarfed by the costs of delay to you. And those costs of delay include the expenses of possibly paying for 2 households, yours and your spouse, especially if it's a situation where you have to support your spouse. And the delay costs also are the intangible costs of damage to your family, your relationships, your career that come with a divorce continuing to linger. The longer a divorce goes on, the more bad things can happen, the more children can hear things they should never hear as their parents are entrenched in litigation, the higher the chance of a business associate being subpoenaed to be involved in your divorce. There's just too many things that can potentially happen that are not good the longer your divorce case keeps going. So that's something you need to keep in mind. Is another reason why you need a legal strategy that helps encourage getting things over with. Additionally, one thing you can't underestimate, if you are in business, if you run a business, or you are in a career to where you have to be at the top of your game, making important decisions and have other people relying on you, anything to where you have to be a top performer at all times, you can't underestimate the cost of a divorce continuing to linger to your business or career. The longer you're involved in divorce, the more distracted you're going to be, the more of your time, attention, and effort is going to be diverted from running that business or performing in your career, to dealing with the divorce, being upset about the divorce, all of those things. So you can't underestimate that. I have a lot of clients that own their own business and they think they can do everything, and they don't really think the divorce is going to have much of an effect on them, but those people, a few months down the line, when things are still going, they feel the pressure. They see how it affects what they're doing at work or in their business, and that helps them realize the benefit to having things done. So don't forget the costs of delay. They are real. They add up. And even when not financial, they can be devastating. So this is all more the reason to have a legal strategy to get things done. One of the methods for helping realize when you do need to get things done is utilizing a net expected value settlement analysis. And this explanation involves a little bit of math and statistics, so I'm not going into it in detail in this course. I guess it's one of the reasons you can buy the Best Divorce book, and you can look at bestdivorce.info. If you're not aware, I wrote a book that deals with divorce strategy. It's kind of designed for regular people. It's not written in a bunch of legalese, lawyer writing. It's more common sense, practical, actionable advice. And in that book, there is a section on how to do what's called net expected value settlement analysis. And you can read through the details with an example there. But the basic concept with a net expected value settlement analysis is that you should settle your case if the current settlement offer has you in a better financial position than you'd expect to get in litigation after you take into account the costs of paying lawyers to take your case to trial, lost income from employment or business with the divorce dragging on, and if you're paying your spouse or their lawyers the costs of continuing to pay them for the expected duration of the case. We can kind of go through a real simple example here, but the basic concept is usually it's best to take an offer of settlement from your spouse that is of less value to you than what you'd get in court. If the money that you're giving up or the extra money that you're paying is less than you'd pay the lawyers to get things done. I tell my clients all the time in these mediations, just give it to your spouse, don't give it to me, get things done with so you can move on, you'll be happier. And that's really the basic concept of this. But to just put some numbers to the logic, you can take the example, say that your spouse makes a settlement offer of $125,000, everything added up and included. It's probably a lower number than what a lot of lawyers are used to dealing with, but say that's the settlement offer is $125,000 from your spouse, but from your attorney, if you go to court, you'd expect to receive $150,000, $25,000 more. But to go to court, you'd have to pay the lawyers about $30,000 to do a trial, which is probably about normal for many situations. So in this situation, it makes sense to take a settlement offer from your spouse that gives you $25,000, less than what you deserve, less than what a judge will order, but that's only because you'd pay $30,000 to get that extra $25,000. So that's kind of the logic, and you can't settle your divorce case through a math formula all the time. A net expected value calculation analysis is just a tool to use for helping determine when it might make sense to get a case over with. There's a little bit more that goes into making settlement offers and negotiations, but it's something to be aware of. And usually, if you can get things done and give less to your spouse, then it would receive less from your spouse, but overall come out ahead, then the position you'd be in if you had to pay lawyers to keep going. It just makes sense to have certainty and get it over with sooner rather than later. When you go to a trial, you can have the best lawyer in the world, but things can get messed up. You can get involved with an appeal. It could take another extra year. You just need to get this done. So keep in mind that a net expected value settlement analysis is a good tool for allowing you to do that. And since the analysis relies on logic and not emotion, it's sometimes a good check for whether the way you're looking at things is really reasonable. So just as a reminder, as I said before, this course is not a substitute for a competent divorce lawyer. You should consult with a qualified divorce lawyer before you act on anything. And this course are the materials, and the course does not create an attorney-client relationship between yourself and my law firm. That is it for today's lesson. Look forward to covering the next topic. Until then, be well.